When Enoch Burke was terminated, dismissed out of his teaching job at Wilson's Hospital School, he was entitled to an appeal as part of the disciplinary process and procedure laid down by the Department of Education for school teachers and schools and so on. And that appeal involves the appointment of an external panel of 3 persons. In Enoch Burke's case, one of the persons who was on the proposed appeal panel was a trade union person called Kieran Christie. Kieran Christie is the ASTI General Secretary, and Enoch Burke objected to this man being on the panel, the appeal panel, because he viewed him as a promoter of transgenderism. So Enoch Burke went to the High Court to seek an injunction to have, or an order to have, Kieran Christie removed from that particular panel. And that panel will decide the employment status or otherwise of Enoch Burke in terms of his appeal. He already has been dismissed from the school, but he has an appeal, and he's perfectly entitled to put that appeal or canvass that appeal and engage in it. But he actually brought the injunction to prevent the appeal hearing from going ahead on the basis that this Kieran Christie gentleman was a promoter of transgenderism and would be biased and so on. The judge yesterday, Mr. Justice Conor Dignam, was satisfied that a reasonable person would not have an apprehension that Mr. Christie is personally or objectively biased, as distinct from through his association with his ASTI position. In his challenge to the panel, Mr. Burke claimed that Mr. Christie was an activist for transgenderism within the ASTI, and that under his leadership, ASTI was becoming a vehicle for the promotion of transgenderism. He referred to Mr. Christie making an award to a teacher in Cork who helped a group of students to establish a sexuality and gender acceptance group in their school. Mr. Christie also worked closely over the years with a group called Transgenderism Equality Network Ireland, that's TENI, which Mr. Burke said was evidence that he was a promoter of transgenderism within the ASTI. The judge said that the only evidence of an association with TENI came from Mr. Christie himself, who said that he met a representative of the organisation once in 2016. The judge said one meeting with a TENI representative 7 years ago would not cause a reasonable person to consider that Mr. Christie has a close working relationship with TENI over many years, as Mr. Burke had claimed. In relation to the claim of objective bias against Mr. Christie personally, on the basis that he presented an award to a teacher, the judge said that a reasonable observer would readily appreciate that Mr. Christie was acting in his capacity as General Secretary of the ASTI in doing so. He's one of the 8 members of the ASTI committee that decides, it's an awards committee in the ASTI that decides on such awards. In the judge's view, no reasonable person would believe, on the basis of those facts, that Mr. Christie was personally biased against Mr. Burke's position. The judge said that there was not even a starting point for his claim, for Mr. Burke's claim that Mr. Christie promotes transgenderism. Mr. Burke, he said, does not say what he means by being a promoter of or an activist for transgenderism, which Mr. Burke defines as the ideology that each person has a gender identity which may or may not align with their biological sex. The judge said that it's clear that Mr. Burke has his ideology based on his religious belief, and that it appears that he believes that anyone who does not subscribe to the same position as him on this issue has a contrary ideology, that is transgenderism. But the judge doesn't accept that. Even if transgenderism is, as defined by Mr. Burke, an ideology, it is possible and even commonplace for a person to not subscribe to a particular ideology, but it does not follow that they subscribe to, let alone promote or are active in, the cause of another ideology. The reasonable person will appreciate that a person can be prepared to accede to a request by an individual, be it an adult or a child or the child's parents, to be called by a different name or referred to by a different pronoun without being a promoter of or activist for an ideology, he said. And the Oireachtas then has made provision in the Gender Recognition Act 2015 for a person to change gender from what is recorded on their birth certificate. This acknowledges that a person's biological sex may not necessarily be the same as that person's gender. The statement by Mr. Christie in relation to this reflects the legal position in the state, the judge said. In other words, it's the law of the land. The judge also said that comments in a newspaper interview by the Deputy General Secretary of ASTI, Diarmuid de Puer, saying students should be generally referred to by their preferred pronoun, was general in nature and representing no more than a general position. The comments were not sufficient to ground the serious question that there is a